If you want to play semantics with me, we can play it all day. If you want to play semantics with me, we can play it all day because I bet you I can beat you. Very well, if you're doing it this way. Well, I'm done with you. Don't say a word to me. Right. Do you have a signed writing indicating anything about that security deposit that's different from what the lease says?
Because he asked that the plaintiff's claims be denied, and he's the plaintiff. So I don't know.
Okay, if the parties are switched or the name on the party, then it makes sense to you. Or at least you may not agree with it, but it makes sense in terms of what's being said.
Yes.
Okay. All right. I guess, and Mr. Stanford, I'm going to just ask this. Your court, in looking at it, believes that there was a what? Well, let me rephrase that. Strike that out. Why do you believe that the resolution of the last case didn't resolve these issues? Why do you believe that the resolution of the last case did not resolve these issues?
Because she still occupied the property. I had no idea what damages or condition the property was in until after she moved out. In that consent agreement, there was the second page on that had a line in there regarding there might be additional damages due to physical damages to the property.
When did she move out?
Oh, she moved out the day before the end that agreement that we had come to. She was going to move out by before the 31st of October, 2024. And she did that.
She did, right. She complied with that part. And then,
so
just go ahead.
So November 1st, I went in and did an inventory, and the pictures you saw that I've submitted to the court is what I saw when I walked in through the house on November 1st.
All right. So how much was her security deposit?
The security deposit that I was holding was I believe it was around 1,020 or 1,050, I believe.
Okay. And so the entirety of the amount, is that all damages that you're claiming in this case?
What I have submitted on one of these forms that I turned in, I had crossed out some numbers and updated the dollar amount of that. Oh,
well, let me ask it this way. None of it is for rent.
no.
Okay. And for all of these claims, there are receipts?
Yes.
And remind me, how long was she in the unit?
You say again?
How long was she in the unit?
How long she was in the unit? She was in the unit for from from 3/23/24 and till October 31st. So about 6 months due date.
So, for example, when was the last time the unit was painted before she moved in?
Probably about a year before she moved in.
And then
But-
she's there 6 months.
Yeah.
So why is she paying the cost of repainting?
Because her kid, her grandson wrote all over the wall, crayons. She's not paying for repainting the whole place. She's paying for to go through and touch up all these spots. And you see it in the pictures, all the crayon marks and everything all over the wall.
Yeah, but that was crayon.
Well, crayon or marker, whatever they were using.
Well, there'd be a difference in terms of cleaning, wouldn't there?
That's not dirt. That's not normal wear and tear. That's
That's not what I asked you. There would be a difference if it's marker as opposed to crayon.
well, I'm not sure what it was, but I tried cleaning it. It would not clean off. What I had to do is I had to repaint. You know, a lot of those markers say, even after you repaint, they'll bleed back through.
So I'm who did this? Um, so I'm trying to figure out. There were items that had to move out. Who moved those items out?
I had to myself and my crew.
So how do I get to 1,090?
Oh, you're looking at it, okay. That was, well, let me review it. Well, that was the labor involved to, I had a total of 10 and a half hours, moving that stuff out, loading it up, hauling it away, and dump fee on that.
So what was the hourly rate you charged?
What we had agreed to in the lease was $100 per man hour.
Yeah, but what were your actual hours?
The hours, well,
I mean,
probably about 10 hours.
all of the labor in here, was that done by you?
Not me, or some of it was done by me personally, but most of it was my people that work for me.
And they're going to testify as to all of this?
Pardon me?
They're going to testify as to all of this?
I did not plan on having them testify, but if I could, or one of them could, the other one has moved to California. I can provide.
Where were these doors? See, I'm going to tell you right now what I got a problem with. One of the problems is the time it's taking to do these things.
The time it takes to what?
To do these things.
Okay.
I mean, you're charging $100 an hour, which is a little odd to me because if you were to hire somebody, that normally would not be the cost.
Well, it wouldn't. Well, it would be if I.
No, it wouldn't.
If I hire a handyman service to come in and do these repairs, the local handyman companies are charging in the area of 100, 125 per man hour.
But they do it quicker.
I would not say that they do it quicker.
You're going to tell me it took you almost 18 hours to replace doors?
That's a lot of work, placing a door.
You know, that's a funny thing. Everybody thinks as a judge, I don't do anything. I just go home, crawl under a rock, and I never repair or do anything. If it takes you 18 hours to install 2 doors, you better have reinstalled the frame, had to knock it out, put wood in. There is no way it's going to take 18 hours.
I know that for a fact because there was a door that I had replaced in that building a couple of years prior to that. And I had real specific time that I've recorded on that. By the time you go order the door, go back and pick it up, deliver it to the job site.
You're paying for the order and pick up at the door?
That door's not going to appear there automatically. How am I going to hang a door if I don't have the door? I've got to go buy it. I've got to order it. Might not.
That's not a labor charge.
It's the cost of doing business. If I came to your house and put a door in, I got to include the cost of me going to the lumberyard, buying that door, delivering it to you.
Well, if it takes you 18 hours to put in a door, you're not coming to my house to do it.
Well,
I'll tell you what, because I'll have that door in by the time you get there.
well,
There's just no way.
to install a door in an existing opening where you've got to cut and bevel the doors, cut the lock set or the passage set into it, bevel or mortise for the hinges. It's certainly, that's what it takes. That's the amount of time it takes to do that.
Okay. At $100 an hour, but you're not a professional in doing.
I am a professional. I'm a licensed builder. I've been doing this for over 45 years.
And it takes you 18 hours to put in 2 doors.
That's the amount of time to be involved.
Okay. All right. No, you'll just get left to your proofs. Because that is an incredible amount of time to do that. How were these 20 bulky items taken away?
They were hauled away by truck by a fellow that works for me.
It took 10 hours to get all this stuff out?
That's the amount of time we had in that portion of it.
I don't know what that means.
Well, What are you specifically asking about? The items that she left behind?
Yes.
All right. We had to pull all that out of the house. I had it in the garage for a while. We all ended up having to load it in the truck, haul it to the dump or the recycle, location.
Well, how long did it take you to get it out of the house?
Well, that was the amount of time I had involved.
How much time did it take you to get it out of the house?
I'd have to double check my specific records on that, but I would suspect it's going to be 2 to 3 man hours to haul this stuff out of the basement, out of each of the bedrooms, and getting it out of the house into the to the garage.
And then charged again to load it from the garage onto a truck.
Right.
Doesn't it seem to you it would have taken less time if we're charging by time? That if you take it out, put it right on the truck, you save time.
If I have a truck ready to go to the dump, that would make the most sense. But
Yes, it would.
but I was gathering stuff up to make sure we had all the debris we needed. I had to figure out how much. It was more than one truck.
Maybe you're not understanding what I'm saying. What I'm saying is you're trying to charge for time that seems to me to be extra time based upon the way that you did it.
I put it in the garage.
I heard you.
That was right where you back a truck up to and then load it compactly into the garage. Once you see
How come when I say something, you try to explain to me like a rationale behind it? I hear what you're saying. I'm just saying you're charging for, you created more work.
No, I disagree.
Okay, but that's the great thing about this. I'm the one making the decision. But you created more work.
By doing what?
By taking it out, storing it someplace, then coming back and then reloading it. It takes more time than if you had taken it out, put it right on the truck and taken it away.
It's a minimal amount of difference. The garage is right next to where the house and driveway right there, and back the truck up to. To pack that truck, I think exactly that you want to see what you've got, what you got to put into that truck. You can't just randomly start throwing stuff in the truck. You'll never have all your stuff in there in an efficient load. I've been doing this kind of work for 50 years and
not very well if you're doing it this way.
Well,
I'm done with you. Don't say a word to me.
all right.
Norman, anything you want to say? Well, hold on a second before we get there. How is the plumbing her fault?
What's the question?
How's the plumbing parts her fault?
They had a bathtub that was backed up, and they were doing something to it, and they broke the trap on that and causing a leak. They were trying to get a bathtub to drain, and broke that. And I had to go back in and fix a bunch of drywall that got damaged and fix the plumbing that they had from the leak that they caused.
Was there an inventory move-in sheet?
Yes, there was.
What portion of the lease has the $100 in it?
Pardon me?
What portion of the lease has that $100 labor charge? Which I'm not sure is legal, but go ahead.
I had a big lease on it's the portion in that lease said if there's damages, they can repair them, or if not, they agree to hire Stanford Enterprises to take care of the.
So in the lease, the tenant agrees to hire your company.
Say again.
In the lease, they can't get somebody of their own choosing to do the repairs.
No, they can't. If there's
Well, what's this about hiring Stanford Enterprises?
well, if they don't fix it, I've got to have my crew go in and do the repairs. If they do damages and walk away.
Where's the $100 thing? It says tenant will pay the company's standard rate. Current rate is service and trip charge of $50 plus $100, right? Per man hour.
Right.
All right. Ms. Norman, you got anything to say on this?
I do. So just kind of going back to how when the case started and that last case that we had the consent order for, he talked about I believe he's talking about number 6, the defendant may be liable for damages. I was concerned about that and voiced my concerns to you, and you specifically asked him on record if he was waiving rent and monetary damages, and he said he was. His counsel was there with him.
Did somebody provide a transcript of that?
I did submit the flash drive of the video.
Right, but what date was that hearing?
10/22 of 2024.
We're running what? We're running jabs, all right. Pull up our copy. All right, go ahead, Ms. Norman. Well, I'm trying to find the official copy. We didn't pull a transcript, but maybe, and I saw what was there, but these days I have to be careful regarding that. But go ahead. What else were you saying?
So I did want to point that out, that he did waive those things. Also, what got us into court was because the property was damaged in the first place. And I did ask the court if I could reopen my case since Mr. Stanford was bringing this back into your court. And at the time you denied it, and there's photos of the damages that were on the property. I'm sorry, I didn't hear you.
Up on move-in.
Correct. And I called the township myself for the inspection, and the house was inhabitable. So there was a lot of things he had to fix, and then he didn't have that certificate of occupancy as well.
The certificate of compliance he didn't have.
Oh, compliance. Okay.
No,
No,
that's-
he did not. My deposit was $3,500. Let's see. And he's talking about this big plumbing issue. I called him the moment that started leaking. I don't even believe we were in court at that time. And he came there and I asked him to remediate that water, or if he had a shop vac, and he said, "Don't you have a mop?" So that was a whole thing. But I was not trying to fix that. I'm not a plumber. I called him immediately. I'd like to just address quickly the amount of monies he's trying to charge me for.
Hold on a second,
Okay.
Stormy. I now see that. What? How much was the monthly rent? I just got to update myself on that.
The monthly rent was 3,300.
So in all of your, I'll come back to you in a moment, Ms. Norman.
Okay.
In all of your estimates, there's a $3,500 security deposit, not the $1,050.
That's right. Police called for 3,500, I believe. She had not paid the full deposit.
So why did she move in?
Well, she wanted to move in. I gave her a break.
And why wasn't the lease changed to reflect that?
Well, she had agreed that she was going to get caught up and pay the difference on that.
By when?
Well, we had
Is there anything in writing to that effect?
we have a couple agreements that
Was there anything in writing to that effect?
don't know that there was some printed things that communications that we had back.
Okay. If you want to play semantics with me, we can play it all day. If you want to play semantics with me, we can play it all day because I bet you I can beat you. Do you have a signed writing indicating anything about that security deposit that's different from what the lease says?
I have records showing what she paid. I don't have a written agreement of what transpires.
So the answer to my question is no, I do not have that.
No.
Were you able to find it?
So Mr. McCurgy was present at that hearing, and he says, we're not claiming money damages for rent. This is only a claim for return of rent. I still have much to listen to, but that's what I've got so far.
That was on which case? That was on the first case, correct? I get why he says that, though. All right. No, I may need a transcript of that proceeding then. Prepared.
Okay.
Okay. All right. Ms. Norman, I interrupted you. You go ahead. What else did you want to point out?
The deposit, and he's making claims that the furniture, removal of the furniture, he calls the city to have that removed for free. Because when I moved in, there was furniture sitting in the driveway, and he informed me that these bulky items all you do is call and they remove them for free. So I'm under the impression that that's what happened in this case as well. I did try to call, I did call and talk to Cindy at the township office, but they don't keep records. So
Right.
but I didn't see any receipts in all of the items that he sent me
I
either.
didn't, but
I see these punch something or other, but I couldn't read them. I don't know what that's about.
this property was located, is it in the city or in the township? In Pittsfield?
It's this.
You didn't have a certificate of occupancy?
The township failed to follow their procedure as far as renewing that.
So the answer to my question is no, you did not,
That's correct.
which means you could not rent.
When she first gave me,
Which means, correct me if I'm wrong, that you could not rent that property.
technically by law,
That's what I deal with.
I
You know, you can call it technicality all you want. That's what I do.
and Your Honor, I don't believe that the failure of the township to do the what they are statutory.
You may have a claim against the township, but if you don't have the certificate of compliance, you can't rent it.
And I wasn't aware of that when we signed the lease.
Okay. So how much rent did she pay you? Because if you can't rent it, you can't charge her rent.
I submitted some information on how much she paid support, and I just did that information here. Let's see. Well, she paid $4,000 on 3/21, and it's the C of O was valid at that point in time, or CC, I guess technically. And again, I don't have that right here in front of me up to date. You need those numbers.
Well, wouldn't it seem to you if you can't charge rent and you can't rent it at that point in time, that you might owe her money? Or that at least gets offset as against any claim that you have?
Is that question or?
Well, if
I didn't-
if I make it a statement, we're done here.
Could you say it again? Because I didn't hear real clearly what you had said.
Monthly rent was about 3,000 something.
3,300.
Okay. If she paid rent to you at a point at which you can't rent the property nor take rent, then wouldn't you owe that back to her?
I don't think the burden should be on me for the failure of the township.
Again, you might have a claim against the township, but you don't have a claim against her.
Well, I think I do.
Okay. All right, then you keep thinking that. Here's what we're going to do. Ms. Norman, you're not intending on being out this way anytime soon, are you?
I can be. I was going to be there today. I just was in the hospital. I have influenza A.
Okay. Give me a trial date. I want to clear it. I don't know if this is going to take all that long.
April 20.
April 20th,
28.
28th. Okay.
Judge Simpson.
Yes, ma'am.
Just so you know, I paid him. It's in the case that I filed before, around $15,000. And all my money orders are there. Everything is there. But just so you know.
In the previous matter, right?
Yes.
Yeah, I know that based upon my memory of the previous case, you paid the money. That's not my issue. My issue is monies that you paid that maybe you shouldn't have paid. And what I'm suggesting to Mr. Stanford is that may offset any claim he has.
Okay.
So what I'm going to do is 428. I'm going to set a non-jury trial. I'll need the parties here in person. I was going to set it for April 28th, 2026 at 9 a.m. So, right?
Yes.
Will that work for the parties?
Yeah.
For me.
All right. And then we'll decide. Pardon?
What was that date again?
April 28th.
April 28th at
9 a.m. And what I might suggest, Mr. Stanford, is that you look at how much she paid during the time at which your property did not have a COC or temporary COC, and determine whether or not you want to head forward with this case, because it may offset anything that you might be entitled.
Understand.
All right. Anything else from either side?
No.
Oh, thank you.
All right. Thank you. Are they ready on this?
My understanding is yes.
Hasim Yasmin versus Shannon Somerville. Yeah, I'm gonna do. Huh? I'm gonna go around and take all these doors off. Then I figure that's 18 hours for every two. That's like $900 a door. We got $1 billion of them. I could make some cash. Anyway, I'm sorry. Go ahead. Counsel, state your appearance.
Your Honor, I'm Hashim Yassin. I'm appearing pro se, and I would like to inform you that I believe we have come to an agreement. And
Okay, why don't you stop right there and let me get this side? Go ahead.
Hi, Your Honor. Good morning. I'm Lazar Georgiev. I'm here with my partner, Justin Yu, and we're requesting permission to appear on behalf of our clients, Shannon Somerville and Joseph Walters Jackson, pursuant to MCR 8.120 under the supervision of David Santacroce. Good morning.
Good morning, Mr. Santacroce. Should I give him permission? Okay, permission to practice is granted. All right. All right. My understanding is there may be an agreement.
Yes, Your Honor. We'd like to put it on the record, the
Yes, go ahead.
initial dismissal. Our clients have agreed to payments of $54 a month for 4 months to be made through Cash App. It will be paid on the 1st of every month, beginning next month, April 1st. And if it's okay with Dr. Yassine, we'd like to be able to prepay earlier if they're able to, but we'll stick to the schedule.
Said $54 a month. Are they in the property? What's that? What's this amount represent then?
This is for plaintiff's claims for unpaid rent. We have a copy of,
So we're here for $216 of rent?
well, Your Honor, plaintiff has claimed
That's a yes or no?
this, Your Honor.
Really?
Well, we also had, they claimed more in damages and we had significant counterclaims in which the,
So the 216 is a resolution of those items.
yes, Your Honor.
Okay. Because if it was 216, that would have been like a quarter of a door. I'm sorry. My bad. All right. Sir, is that a full understanding of the agreement?
Yes, Your Honor, in the spirit of reaching an agreement and having peace of mind to all parties involved, we came to that agreement and we believe that we are both benefiting from it.
Okay. Has that been reduced to writing?
We will prepare it,
You didn't do it?
just struck.
Your students, shouldn't they have done it by now? You know, if you're going to the University of Maryland, you'd have this all done. How soon am I going to get an agreement?
Your Honor, we'll work on it, get it to the other side and file it within the next 2 weeks, if that's okay with you.
2 weeks? What do you have to do in 2 weeks?
This,
What you got? What? You just came back from break, right?
Yes.
You just came back from break. You don't have classes every day, do you?
I do personally.
You do? You're doing it wrong. You're doing it wrong. What?
I asked for 2 weeks. I said, ask for 2 weeks because it's got to go over there. We've got to get a signature. It's going to come back. We don't want to be late for the court.
How does it feel with that sword in your chest falling on that for your students? No. That's fine. We'll give them 2. Do you have a problem with 2 weeks?
No, Your Honor.
You really think they should do it faster though, right?
Your Honor,
No, and I don't want you to do it. All right. What I will do, and you're going to be doing this by way of a conditional dismissal, is that correct? All right. I will mark this file conditionally dismissed. Order to follow in 14 days. All right.
Thank you so much, Your Honor.
Thank you. Thank you. What'd you say?
I was cracking up.
I always think that. See, told you, I'm awesome. I know, Mr. Oh, Mr. Allen doesn't think so, but
Have a great day, guys.
you guys do the same.
Thank you.
have a nice day, Your Honor. Thank you very much.
Thank you. I know.
So you
What is that? So that's done. To
it's there's a lot of motions. It was included in that, yeah.
Court does call the case, fixing housing 401k plan versus Erica and Aaron Ward. Council, state your appearances.
Wayne Velez on behalf of the plaintiff.
Erica, Aaron Ward, defense.
All right. I think, counsel, did I not have from you a motion to withdraw?
Your Honor.
Pardon?
Yeah.
Okay. I also have, and I don't know whether or not you were served with them because I'm not clear what entirely what Ms. Tope is doing. But did you receive from Ms. Tope a motion to remove and expunge the court's order?
Got an email copy of it that I'm aware of, yes.
Okay, so you,
I don't know the result of it though.
well, first of all, I can tell you part of the result of it is that she marked it an emergency. I did not deem it an emergency. So I set it for hearing today along with the other motions. Okay, that was the resolution. The reason did you folks receive a copy of that?
Not sure what you're referring to. I don't know anything about it.
Donna Tope's motion to remove and expunge the court's order for contempt. Okay.
I don't know. I didn't think I was.
Not received. You got an email copy. All right. So then we received, and I guess I'll deal with that one first, if you don't mind. We received then a communication from Ms. Tope that she was unavailable for her own motion today. So that motion, Donna Tope's motion will be adjourned. And I'm not changing anything. The bench warrant is still outstanding. So my next day.
March or April 14th.
14th?
Yeah.
I'm a little busy that day. March 17th, 2026, 9 a.m. So that I'll adjourn the Donna Tope's motions. Counsel, I'll leave it to you, given your motion to withdraw, as to whether or not you want me to finish ruling on the other motions or hear your motion to withdraw.
What it's my understanding, the last hearing you ruled or granted liability or the motion to stop the motion, and we're here today for a hearing on damages, which I suspect we're prepared to move forward with that might result in the conclusion of this matter, which might make my motion to withdraw moot to a certain extent, and also make the defendants, we're calling it the second omnibus motion, might make
Pardon?
moot as well.
Oh, yes. All right. Folks, what do you have to say to me on the issue of damages?
So the issue on damages. Okay, so the thing he was referring to as a second omnibus motion. I just was preparing that because I was under the understanding today was the final day. You already ruled on the eviction. You were going to rule on when and the damages. Okay, so since then, there were new things that happened, such as foreclosure being posted. I've lost a lot of orders and I'm out of business. So regarding damages.
You're out of business?
Yes, and I do not have enough orders to pay my lease starting April. Most of the boarders are leaving at the end of March. They saw the posting on the door. Horse owners are like horses, they're flight animals, they're herd animals, and they're all leaving, and I'm going out of business. And so I fear, because of the posting of his foreclosure on the facility, that he is foreclosing and possibly going into bankruptcy. And so what I'm asking for damages is that it be to come out of the court's account. And that, so that my understanding is damages is up to you. And I have no recourse to get any of my money. I'm out of business. I'm not going to have the money for April's lease because of the eviction.
Let me just stop you there a moment, okay? Because you know about the foreclosure
Yes,
council and it's a bank foreclosure.
it wasn't a bank foreclosure, but it was the lender.
Well, okay, the lender. Have they leaned anything in regard to that?
I'm not aware of a lien. There was a foreclosure sale on the 4th, which the lender purchased the property out of foreclosure. So the redemption period is obviously still ongoing, but
Oh dear. Okay. And so when we had received, and I don't know if you were aware of it, counsel, I think it may have come in maybe in response to your motion to withdraw communication from your client that it was going into foreclosure. But it actually has gone through that process and then there.
yeah. And so I just want to make sure that we're clear. So there's the foreclosure sale on the property at issue on the 4th. My client's personal house is also subject to another upcoming foreclosure sale.
That's a different one.
Those are different.
Got it. Okay. And so you have to remind me, how long is that redemption? That's not a 6-month redemption, is it? Going to be
I believe it's 3, but
3. Yeah, that's what I was thinking. Go ahead. You were.
I filed this motion so that you would have all the information in front of you so that you could make a final decision on damages. Or whatever it's called. He asked me to be, he evicted me. He asked me to leave. I'm prepared to leave. I've found a place for my horses. Most of my boarders have already given me notice. And because of the foreclosure and the eviction, the fences that have always been falling down are falling down worse. I can't keep the horses safe, but I don't have the wherewithal or the resources to fix them. And I can't go on. And I'm prepared to, if you would be willing to prorate into the court's account 10 days in April, I would be prepared to leave in 30 days from now. And
What did you mean by that prorate into?
Well, so I usually pay at the beginning of the month for the whole month. I won't have the money to do that because majority of boarders
Gotcha.
are leaving.
I guess. Okay.
Yeah.
What you're saying. All right. This has got to be a disaster in the making, I think. When let me do this. While not holding him to it, counsel, is your client seeking to redeem the property or?
I believe in the best case scenario, yes.
Gotcha. You guys are gonna have to, so let's say he doesn't, and then there's a new owner of the premises, you're probably gonna have to leave in any event. So when can you guys leave the property?
I would love to leave April 10th, but I can leave at the end of March, if you're not able to give me a prorated lease payment for the 10 days of April.
What do you have a total in escrow?
20,620.
Say again.
20,625.
I'm sorry, Your Honor, you said that's what's in the court's escrow?
Yeah, I was asking. It was 2625.
20,625.
And you folks have already paid the March payment. Right.
Quick question, the March payment, are we saying that was paid into the court's escrow?
Yes, they said they paid that.
Last one being February 5th.
So you don't have a March.
To 1 March.
I didn't bring the receipt with me, but I did pay it March. I paid it. I paid it at the end of February because it was before we left on vacation. I think I paid it the last Friday of March because we left on vacation Sunday. So I want to make sure it was in before we left.
Did you pay?
I'm sorry, the last Friday of February. We paid it cash the last Friday in February.
Did you pay it here?
Or in Tulane.
Well,
It really wouldn't matter. Do you know what court you went to pay it?
no,
I do see it because you paid it here. It's not on the ROA. So
And then it's got to be transferred over. So 5,500 additional.
So $26,125.
How long was your lease?
it was supposed to be 7 years.
You have how many horses are you moving?
I'm sorry, how many am I moving?
How many? Yeah.
Just my personal horses. Everybody else,
Okay. That doesn't answer my question. You're getting like that other guy.
I own.
3. So come the 10th as you're anticipating, you're moving 3 horses, or are you moving 3 horses and then some others that you're in care of? I guess I'm trying to.
There's 3 other horses that are absentee owners, and I haven't reached out to them yet because I was waiting to see when my leave date was. I'm going to reach out to them and see if they want me to take them because I'm just going to a friend of the family's and they're just pasture horses. But no, I'm not continuing this business. Does that make sense?
No, well, yeah, there's a lot more information I needed, but I'm just trying to figure out if I were to give you till the 10th, you're moving at least 3 horses, but up to 6
Yes.
total horses.
Me personally, yes.
Right. Okay. And as you're moving them, I know approximately what it's going to cost to move horses, but I don't know how far you're going. What's your cost in moving those horses? Just give me your three.
$100. I mean, if that, it's my trailer, my truck,
Okay.
my gas.
So you don't got
Correct.
all right. Okay, before I make a final determination of the damages on this, any other additional argument you want to make regarding that?
Yeah, a couple points,
Yes, sir.
just so that when I'm on the same page and we're all on the same page. So I have back in June of 2025 was the last rent payment. And it was a partial payment that was the water heater. Subsequent to that, until this court directed Ms. Tope and defendants to submit money to the court's escrow, I believe there was the subject of a number of hearings prior to this that Ms. Tope had an escrow account personally where she was maintaining monies of some sort for June until, because I have, for example, as of March, a total outstanding rent due of $48,691.04. $26,125 of that is accounted for in the court's escrow account. And the other $22,000 and some change might be in Ms. Tope's escrow account, which started this whole issue. And so
can I just stop you there? That you understand what counsel's indicating about the difference in the money?
One correction, I did pay 16 Houses LLC directly in July. I paid them the full amount in July.
Okay, but we still have a discrepancy. Well, so I'm going to ask you folks a question. Okay. Did you give that money of these missing, I'll call them missing, but the payments that did not get to the plaintiff, did you give those monies to Ms. Tope?
They were dispersed. That's the money that was dispersed for repairs.
Okay, but what I said, yeah, okay.
Yes.
Hold it. You did not, okay, listen closely to my question because it's really important. You did not disperse those funds for repairs, right? You gave that money to Ms. Tope, who was holding it in whatever to then disperse for repairs or pay for repairs.
Yes.
Okay, because hold on, understand, there's a reason why I'm asking this, and there's a big difference. Okay, because what counsel's indicating, I believe is correct, but I just want to make sure on the record that we have it. The $5,500 that you would pay each month that you would have normally paid to the landlord in this case, there were some months you paid those funds to Ms. Tope to hold and or to use for repairs and other things.
I believe that was August, September, October, July. I paid.
Hang on a second. Hang on. Just slow down. I didn't ask what months. I want to make sure that factually because Ms. Tope's not here, factually that's correct. Because that's what I understand also, but I don't know that you've ever been asked that directly.
Yes.
Okay. So there's in this escrow, and you're saying that that was 3 months. If I'm hearing you correctly, that you would have given the monies to Miss Tote.
I would have to look at the accounting records, but I believe it was August, September, October. I believe it was.
Yes. August, September.
November, it paid support, right?
Our first payment was, I think that's right.
And just so that we're on the same page, I believe the November payment was paid to my client and it was a partial
It
payment.
was a partial payment in November. Right. So,
But I also paid
but you paid the difference of the 55
People.
to the court. No, you paid the 55, but part of it was the check he received.
Received, it was a double payment that month because of an error by Ms. Tope. So he received the check from Ms. Tope. He also made the payment. So that month had extra.
I believe in November, we paid the full 5,500 to the court. Is that correct? So was it 41?
You pull me
25 is what we.
He received it
41.25.
Yes. He got 3,600.
on top of that.
So it was more than the 5,500.
It was $3,508.96.
I remember that being paid. That because that was a check Ms. Tope sent to him. Right.
I don't know how we got it, but my records show that we got it.
Right. That you got it. And the question was whether or not you could pay or whether or not you could use it. And because there was then the full amount, I said, you guys keep that money. The difference I thought was being paid into the court.
And so I accounted for that in my previously stated number. So I'm just trying to bridge the gap between what the court has and what hopefully should be in Ms. Tope's personal escrow account.
Okay. And that number you gave me was 48,691.40.
Not 44, so 4 cents.
4 cents.
4 cents.
In November, though, it was overpayment. Because we paid
Well-
25 and 3,500.
Well, I don't know if we can really look at it as an
Okay.
I mean, because ultimately there's going to be a certain amount that should have been paid. The real question is where it went. I guess is that.
I think that's what you were going to ask for.
Yeah, that's what it was. Okay, and I know why that happened. What I did is I think I prorated. So I allowed him to keep the check. It really wasn't a double payment. So here's what I recall doing is the money that was sent to the plaintiff, I allowed him to keep that upon the court's original. And then when ordering escrow, I ordered it pursuant to the court rules so that it was ordered prorated for the period in time. And I went back, although you paid it on the 18th, it was back around the beginning. When was our first? You didn't run the whole thing, but whatever our first date in November was, I prorated it from a date in November, which is how we came up with that number. So there wasn't a full amount that was going to need to be paid in November. All right. You complied with the escrow order. If you didn't understand all that technicality and what I just said, but I understand why that number is different. And I didn't order the whole 55 for November. All right. But in terms, okay, so here's going to be the problem. And I don't know whose problem it's going to be. and this is gonna, I don't think that the monies you paid were properly put into a trust account with Ms. Toe. That causes huge problems, which I don't know what I'm going to do with entirely. Because and I'm not sure of the procedure, but typically and I know it's changed certainly since I've had to do it, where an escrow account or an IOLTA account is mismanaged. There are ways to the state bar of making the person whole. Now, having said that, and that's there used to be, well, I'm sure there's got to be a way of doing that, but I just don't know how that is. Because you guys are never going to see, well, let's put it this way. You guys are never going to see that nice term. Have you asked her for the money back?
No, they're not.
I don't think that money's there. I think that that's the money that was used for replacing the sheds and all of that. So,
That's not as good.
okay, no, I'm never going to get
But
money back.
here's the problem, okay? And just follow this here, okay? And I think, guys, he's got an Alabama shirt on. Tackle him. No, I'm kidding. Under the terms of the lease, which is the basis upon which I indicated the monies, you have to pay them, right? That money should have been paid over the plaintiff. Okay?
Money should have been paid every month.
Been paid over to the plaintiff.
Should have been paid
Yes.
over to the plaintiff. Okay? I ruled that.
Yes.
Okay? The problem is that it's hard. So I can't really necessarily give an offset. What really should happen in this case, right? Everything being equal and everything being what it is, and if Miss Tope were participating as one would think a member of the bar should, what should happen is the moment that I ruled that that money should have gone to plaintiff, regardless of whether she spent it on, if she did that improperly out of an IOLTA account, she should then pay that money to plaintiff. Right? You guys wouldn't have to pay more. Okay. That's not going to happen, I don't think. So while let me put it this way. She may have told you those were legitimate expenses. They weren't legitimate expenses.
I hear you.
And so what I'm toiling with, just to be honest with you, is in looking at these numbers, do I hold you accountable for that? Or what do I do with it? Now, I'm toiling with that because also, which is also part of the hearing that I adjourned to the 17th, and why I would be reluctant to let counsel out right at this moment in any event, although it may be moot, is because the bond that I set on the contempt, that would be money that Ms. Tope may pay in, was specifically going to be directed toward attorney fees that were being exponentially imploded because of Ms. Tope's actions. So I'm going to ask you guys to just give me a few minutes. I'm going to step off because that my problem is everybody in this courtroom has been hurt by this person. And I'm trying to find an equitable way to deal with that. Counsel.
I have one suggestion.
Yeah, sure.
And theoretically, how it should work is if the defendants have paid money to their attorneys and I owe their account, equitably, that's still their money, which as you alluded to, would mean that that money is no longer there. They would have a claim against themselves, most likely through the bar agreements or whatever form they choose. My client does not have that remedy. And so, because we don't have a relationship with Ms. Tope. She's not my client's counsel. She didn't hold, I don't have an IELTS account with her, or neither does my client, for example. So in this scenario, the money that was in there, the defendants, I mean, their contractual obligation is still on them. So if they pay, then their remedy would be, they would actually have a remedy to get it from Ms. Tope, where my client really theoretically would not. I mean, there might be a creative way to do that, but I'm not aware of those. I've never had a situation like this before, but
you wouldn't me either. But no, I hear you. And that really had gone through my mind. But and that may be where I land in the next 15 minutes, right? But this is the second case in which Ms. Tope has been involved where people have been damaged. This is really the only one, however, that has damaged both sides, and then to a certain extent, the attorney on the other side, because your fees haven't been paid. And I want to just take a moment to think all that through. If I come up with something creative, I may come up with something creative, or I may not. I mean, I may indeed, and I appreciate what you're saying, counsel. That's where I may land. But I want to just think about that for a moment, because I, quite frankly, have never been through anything like this before either. And, you know, your client's out, your fees, plus he hasn't gotten the rental income. These folks have paid they're out at least what that difference is because they paid it over. So, and now because of all of that, and I'm not saying it's the entire cause, but because of all of that, he's in foreclosure. You're not in business. It's a beautiful scenario. And shouldn't be how things should work.
What should happen when a defendant changes his mind after already pleading guilty? That question came before the court when Antonio Vellator appeared for what was supposed to be a sentencing hearing. Instead, his attorney surprised everyone by informing the judge that Vellator wanted to withdraw his guilty plea. Rather than forcing the case forward, the judge asked the defendant directly whether that was truly his decision. After receiving confirmation, the judge granted the request and immediately began preparing the case for trial instead. The attorneys discussed how much time would be needed, taking into account the use of a court interpreter and the expected witness testimony. After hearing from both sides, the judge scheduled a 2-day bench trial, ensuring both the prosecution and defense would have adequate time to present their evidence. The hearing was a reminder that although guilty pleas are serious, courts can allow defendants to withdraw them before sentencing under the right circumstances. Later in the session, another defendant entered a no-contest plea to a misdemeanor larceny charge. Before accepting the plea, the judge carefully explained every constitutional right the defendant would be giving up, including the right to a trial, the right to appeal certain issues, and the consequences of being sentenced as though the plea were guilty. The judge confirmed the plea was voluntary, reviewed the police report, found a factual basis for the offense, and accepted the agreement that dismissed the remaining counts. Defense counsel then asked for immediate sentencing because the defendant had already accumulated significant jail credit and completed treatment, but the judge declined, explaining that sentencing would proceed after a formal pre-sentence investigation. Instead, the judge granted a personal recognizance bond so the defendant could be released while awaiting sentencing. The hearing highlighted two very different stages of the criminal justice system. One defendant was given another chance to fight the charges at trial after withdrawing his plea, while another accepted responsibility through a negotiated agreement and began preparing for sentencing. Here's today's question. Should judges make it easier for defendants to withdraw guilty pleas before sentencing, or should those decisions become final once the plea is entered? Share your thoughts in the comments, and don't forget to like,